Hello and welcome. Welcome to Children of Darkness and Light. Today is True Crime Wednesday, and welcome to everybody who's joining us for True Crime Wednesday. I'm going to give it a couple of minutes here to let folks join us. And in the meantime, I want to just talk a little bit about what's been going on as we move into the new year. I want to wish everybody a really happy new year. Hope you all had a great new year. I had my younger sister here for a few days, which was amazing. She may drop into the chat. So, hey, Tam. And it was great having her here. She had a nice visit with Mom, and it was just wonderful to have her here. And I miss her already. So she went home last night. But now we're going to sort of hit the ground running and get some things underway that we've been talking about for a while. So within the next week or so, you should be seeing some pre-recorded videos about our quilt guild, our true crime quilt guild. You should be seeing the first videos about how to pick your fabric and what tools you're going to need. That should be coming up in the next week, along with the first video on how to start the first square. I do want to tell everybody I might be a little slow today. I'm recovering from having had my annual or my routine colonoscopy this morning. So I'm still trying to recover from a little bit of those drugs. And so if I'm a little slow on the uptake, please bear with me. I have a long family history of colon cancer. Hi there. I just realized my mic was muted, and here I've been talking. And so I hope that you heard part of that, and it was just a glitch on my part as I was clicking through things. So I do want to say that if I'm a little slow on the uptake today, it's because I had my routine colonoscopy this morning, and I'm still in the recovery mode from that. If you know, you know. Have a long family history of colon cancer, and so it is one of those tests, routine medical tests, that I'm pretty faithful about making sure I do, even though it is without a doubt the most unpleasant experience in the world. So thanks for joining us all. We have 138 of you already. Thanks for joining us. As I was, I wasn't muted long. Good. Sorry, as I was clicking around trying to line up some things I want to talk about. So those are all things that are going to come up soon. Thanks to all your good wishes for my colonoscopy. The news was excellent. I don't have to have another one for 5 years. Yay. So I appreciate all your good wishes. It's just the cost of getting older and making sure you want to be around for a while. I have a bunch of things we want to talk about tonight. First of all, there are, I got to look at my notes. First of all, I want to talk a little bit about some new developments in Gabby Petito's case, believe it or not. It's some interesting developments that a couple of folks asked me about, so I thought I'd comment on those. Then, of course, we're going to talk about Brian Kohberger, who either is on his way or has already arrived in Idaho. He left Pennsylvania today. This morning, the state police there picked him up, and it appears that he is either en route or may have arrived very shortly. So we're going to talk about him. We're going to talk about his court-appointed defense attorney. There's a juicy new filing in the Lori Vallow case that we'll probably talk at length about. I'm sure we'll have a lot to talk about on Friday about this, but it was too good not to share tonight. It was filed yesterday. And then I have a new case that probably most people are not aware of, but that one of our followers asked for, and that's to talk about Sandra Birchmore. And it is a sad, sad case. So I am going to talk about that. So let's get started with talking about Gabby Petito. Now, as you may know, Gabby Petito's parents filed a lawsuit against Brian Laundries' parents for intentional infliction of emotional distress. That is a civil cause of action that is available to people in situations where they have been so terribly oh Lordy. I'm sorry, I had to look at an incoming message. I think that is a cause of action that's available for people who have been terribly distressed because of someone's intentional action. Brian, they're also asking to join Brian Laundrie's lawyer in the suit. I believe it is also a wrongful death suit, but I didn't take the time to look that up before I came on the air. The Laundries said publicly while the search for Gabby was going on that they hope that the search is successful and that Ms. Petito is reunited with her family. All the while, Brian Laundrie's mother, Roberta, had written him a note offering to buy him a shovel to help bury Gabby Petito's body. They knew very well that Gabby was dead, that Brian was, their son Brian was responsible for it. And throughout the whole thing, they they did everything they could to throw everybody off and to protect him and to keep him from being prosecuted. And to me, that certainly deserves a filing on behalf of the Petito family. So it's interesting that there is a process by which a civil case can be challenged, and the defendant can say there's not even if you believe everything the petitioner has said, it doesn't rise to the level of a civil cause of action. It's called a summary judgment motion. They very rarely succeed, but occasionally they do, and it's usually big news when they do because they're kind of rare in succeeding. The reason being is that the judge has to look at the evidence and the pleadings in the light most favorable to the petitioner or the plaintiff. So it's unusual for a case to be thrown out in summary judgment, but the case did survive a summary judgment challenge, and the judge did agree that the Petitos could go forward with their suit against the Laundries for intentional infliction of emotional distress. So it will be interesting to see how that case turns out. It is somewhat unusual, as I say, that it's not an easy kind of a cause of action to file. But on the other hand, it appears if there is not a situation that warrants it, if there's any situation that warrants it, it's this one. So I want to talk a little bit about Brian Kohberger. Brian Kohberger is the person who has been arrested on suspicion that he is the perpetrator of the University of Idaho college student murders that happened in Moscow, Idaho. Kohberger is kind of an interesting character. He is from Pennsylvania. He graduated from college with a bachelor's degree in either criminal justice or criminology. It's a little bit unclear at this point. He also got a master's degree in criminology and was in his first semester as a PhD student in criminology at Washington State University in Pullman, Washington. Now, anybody who knows the geography, and for those who aren't familiar with the geography in the Northwest, Pullman, Washington, and Moscow, Idaho are virtually just a few miles apart across the Idaho-Oregon border on the far eastern edge of Oregon and the western edge of Idaho. So people often go back and forth between Pullman and Moscow pretty frequently. For one thing, Oregon is one of the states that's still one of the 2 states in the country that doesn't have sales tax. So a lot of people who live close to borders scoot across the border to do their shopping. So it's not at all unusual for people to go back and forth between Pullman and Moscow. They're almost like sister cities. So Brian Kohberger was a student, a master's degree student. He is 28, so he's a little bit older than the students who are undergraduates who would be at either university. He was living in an apartment, and he was living in an apartment in Pullman. But as I say, they're just right next door to each other across a border that's just basically a sign on the highway. So it is, I've been told, I've heard, and we've been told, there's rumors going around quite extensively, that his DNA was left at the crime scene and he was identified by his familial forensic genealogy, basically, by a familial connection to DNA that's in a database. So typically what's been happening is this new and burgeoning field of genetic forensics and forensic genealogy have been turning up links to people who otherwise are not in a DNA database. Now, knowing that Brian Kohberger is a criminology student, I find it doubtful that he himself would have put himself into a DNA database such as Ancestry or 23andMe. But there are a lot of, it could be a second or third cousin that could be the connection. But there are experts who are now mining that forensic information for data to be used in criminal prosecutions. So we understand that there was some sort of a familial DNA link that was their first clue. I do want to talk about one thing that has come up and has appeared on a couple of people's YouTube channels and has kind of been, it's a rumor that has been kind of perpetuated on social media. And I do want to be clear about, we deal in facts and we don't mind speculating about what those facts might mean. but we're not making stuff up out of whole cloth. Oops, I almost said the other S word. We are not making stuff up out of whole cloth. There is a rumor going around that there was some information about someone at the jail where Brian Kohberger was being held that was screaming irrationally, exposing himself, doing some very troubling and mentally ill behaviors. And somewhere along the line, that behavior was attributed to Brian Kohberger. You all are now in the know. That did not happen. It was a different inmate in the same jail where Brian Kohberger was. It was not him. He did not have any sort of a mental health breakdown, and he was not screaming and hollering in the jail. And if you see anybody else speculating about what that might mean about Brian Kohberger's mental health, you know, because you're on notice now, that's what lawyers say, you know that's not true information. We are going to deal in facts, and we are going to give Mr. Kohberger the presumption of innocence that every citizen in America is entitled to. And that means that we're going to let the facts and the information in the case play out, and we are not going to become part of any of those sorts of, rumors. We're not going to perpetuate those kind of rumors here. That's just not right. This is a picture of Mr. Kohberger yesterday going to court. It's interesting. He's wearing a bright red jumpsuit. Bright red jumpsuits in any jail or any prison denote high-risk prisoners. So you can also see that there are several officers involved in his transport. He's wearing a bulletproof vest. These are all things that we have seen in other perp walks like this one. So I just thought it was interesting that he's wearing a bright red jumpsuit. A lot of people have commented on the fact that his eyes look angry or dead. I'm not going to comment one way or the other. I think that a photograph catches a person in a moment and catches that person's emotions in that moment, but may not accurately describe their mental state at the time. Might not accurately reflect their mental state. Could be, a passing thought. Could be, ooh, my handcuffs are too tight. Or so I don't know that we need to make a lot of that yet. So I want to talk a little bit about what we know so far. We know he was picked up by the Pennsylvania State Police, and from the jail, he was released from that jail into their custody, which means that he's being transported. When I looked online, there were lots of people who had staked out the small airport, the small regional airport just outside of Moscow, hoping to catch a glimpse of them bringing him in. But for now, that's all we know, is that he's probably on his way here. We know that attorney Ann Taylor was appointed. I've looked her up on the Idaho State website. She is death penalty qualified. She's 57. She's quite an experienced lawyer. She's, from what I can tell, has 20 plus years of experience as a defense attorney. She's especially known for a case that she got dismissed because she was able to prove that police had made false statements about the case. So it is interesting that folks who are on the scene in Moscow saw her and her team at the crime scene yesterday. So apparently she knew as early as yesterday, after he waived extradition, that she would be appointed to represent him. She was there with a typical team of investigators and what appeared to be a crime scene, um, a person who, there goes my drugs from this morning, a crime scene reconstructionist for to be able to reconstruct the crime. And nowadays what happens is that there are these amazing video programs that put the entire premises on a 3D model of the entire premises, and then allow the defense to actually walk the jury through the house and walk the jury through either side. The prosecution also has that technology. So it's typical in cases where a crime occurs inside a building to have that kind of a 3D mock-up and be able to literally physically walk through the premises. And they use a lot of the measurements and the photos and the other things that they take when they're investigating a crime scene. So she was there for several hours, and she and her team were there for several hours, and are now working hard to apparently to put together the initial, to preserve the information at the crime scene before it's remediated. You'll recall a couple of days before Mr. Kohberger was arrested, the prosecutor had cleared the company to come in and remove all of the biologic evidence and to clean up and remediate the site. And that work was stopped very quickly within a couple of hours because of Mr. Kohberger's arrest. So it's fortunate for the defense that that was done, and they were able to get in there and get their own experts in there before it was cleaned up. So before I get to the filings in Lori Vallow, because they're juicy, I would like to talk a little bit about a case that one of our good friends of the good Lori brought to my attention, and which I find really interesting. And that is the case of Sandra Birchmore. This is Sarah. I don't know how old she was in this photograph, but that is her. And Sarah grew up in Stoughton, Massachusetts. And in Stoughton, Massachusetts, the local police department has an Explorer Scout program. Now, for those of you who aren't familiar with Explorer Scouts, they're often associated with government agencies, a lot of military organizations, Civil Air Patrol, a lot of police organizations have Explorer Scout posts, and they're intended to have young people experience what it's like to work, say, at a fire department or a police department. And that is what Sandra Birchmore was doing. She was an Explorer Scout. She was deeply interested in law enforcement, had a real love for law enforcement, and was an Explorer Scout at the Explorer Scout post that was hosted and sponsored by the local police department. Two members of that scout post had been Explorer Scouts themselves. They were twin brothers, and they had become police officers, and then had been asked if they would become instructors and leaders for the Explorer Scout post. And so they and their director of the program were accused of having groomed and sexually assaulted Sarah. Sarah began involvement with that Explorer Scout post when she was 13. It's clear from the evidence that was released in a highly redacted report from the police agency that there was a great deal of grooming and then ultimately a sexual relationship between Sarah and at least one of the two twin brothers, likely both of them, as well as the director of the program. At age 23, the officer that she was having a relationship with her went to her apartment and told her that he was breaking off their relationship. She was 3 months pregnant. And 3 days later, she committed suicide. Her suicide resulted in there being this investigation, and in probably one of the most frustrating things I've ever heard. The internal affairs investigation into the police officers was ruled insufficient evidence because they needed her testimony, and bummer, she was deceased. So her parents have now filed a wrongful death suit against the police department and against the Explorer and against the three individuals. And I appreciate that it's been brought to my attention, and I'm going to continue to follow it. You know, I represented at one point a young woman who I don't know whether this is the case with Sarah, but the young woman I represented had some developmental disabilities, and she desperately wanted to be a firefighter. And the program that she was in connected her up with a Explorer Scout program, similar. I'm not sure it was exactly Explorer Scouts, but with a similar program that allowed young people to, for lack of a better word, volunteer at the at the fire station. She and several other young people volunteered routinely at the fire station, and they did a lot of work. They cleaned up the kitchen. They helped restock shelves for medical supplies. And on very rare occasions, they actually were allowed to go out on calls. They also participated in a lot of the community activities. This particular fire department had a big program at 4th of July. And so the cadets were always very involved in the 4th of July celebration. So really a fun and exciting experience. I can't say that it didn't cross my mind at any time that my young client was a particularly vulnerable young person. And so I was very cautious, as were the people in her program, to make sure that things were on the up and up and that she was being safely supervised. I was very fortunate that in that particular fire station, the captain at that fire station had his own experience with developmentally disabled adults, and he was very cognizant of making sure that they were never put in situations that could be misconstrued, either by them or by the leadership. So these programs can be wonderful for young people, but they also bear an awful lot of scrutiny, and I will be very interested to continue to follow that case. So I really appreciate the follower that sent it to me. Now let's talk about Lori Vallow and the juicy stuff. Interestingly enough, yesterday, now y'all may recall here, I'm gonna remove sweet little Sarah here, and I'm gonna put this up. If you see up here in this graphic, yesterday, Jim Archibald filed a notice of intent not to use mental health defense. Interesting, no? So here's what's fascinating to me is that less than 4 weeks ago, Jim Archibald was in, maybe 6 weeks ago, Jim Archibald was in court saying that we were going to hear about Lori Vallow's diagnosis, her mental health diagnosis at trial, which I took to mean that they were going to be using her prior mental health issues as a justification to say she was so mentally ill, she did not have the ability to form the intent to commit the crime. Because remember, Idaho doesn't have not guilty by reason of insanity. Idaho doesn't have guilty but insane. There's no mental health defense available. But there is an argument that if you have someone who is so mentally ill that they can't form the mental state to intentionally take the life of another, then there is an argument that they could that they're not culpable because they couldn't form the mental state. So it's kind of a roundabout insanity defense, but it's still available. It seemed obvious to me, at least, and lots of other people I've talked to, that that was about the only thing that Jim Archibald had, was to be able to say Lori Vallow was so mentally disturbed at the time that she participated in the planning of these murders or participated in the murders. We don't know yet, whatever the evidence shows, that she was so mentally ill that she couldn't form the requisite mental state. So that appeared to be what everybody was expecting that would happen. Now, Jim Archibald has announced they will not be using a mental health defense. So that's fascinating because we don't know what else they might have. It seems like they may not have a lot. So it will be really interesting to see how they're going to go forward at trial without bringing up her mental health. One does wonder why it is that they've made that decision. So I want to call your attention and reflect back on the fact that back in November, late October, I believe, they asked for a subsequent evaluation of her mental state. Interestingly enough, we know because even though the documents are sealed, it showed up in a caption, and my brain isn't pulling up the name, but that somebody was objecting to her having an evaluation by the same psychologist who evaluated Brian David Mitchell in the Elizabeth Smart case and found him competent after he had been malingering for quite some time. So it appears that this defense attorney, this expert sort of has a little bit of is an expert in malingering, and they were seeking to have her evaluated by him. We don't know whether that evaluation took place or not. We only know that the prosecution was objecting to it. I think it was the prosecution, but now that I'm trying to see the database, I'm not sure. But one side was objecting, and that was the reason why we even knew that they had asked for this particular expert to evaluate Lori. So interesting, because Now we have them saying they're not going to use that mental disease defense. I'm wondering, and I'm speculating, that the reason is that that evaluation was not favorable toward Lori, or that it indicated that she was malingering, because they have been really wedded to this defense of this mental health defense. And Archibald has on several occasions telegraphed their intention to use that mental health defense. And then suddenly yesterday, they dropped this little bomb of we're not intending to use mental health defense. So interesting that we can sort of speculate and extrapolate from that last evaluation was not helpful to Lori. And that undoubtedly, because those evaluations have to be shared with both sides, undoubtedly the prosecution has that report and is going, yeah, bring it on. Let's talk about her mental health. So it's going to be fascinating once we're able to actually access the files and the information post-trial to see how well we did at reading the tea leaves and speculating about that stuff. So absolutely fascinating new development. And I'm sure that we will be talking a great deal more about it on Friday. We also do not know, we know that John Pryor has telegraphed through an objection to the court scheduling motion that he is intending to file yet another motion to continue the case. We haven't seen that motion yet, and we don't know what is going on with that. Reasonable minds can differ. I think there are some people who feel that he's going to get his continuance because he doesn't want Judge Boyce doesn't want an ineffective assistance of counsel challenge because he short-circuited his rights. On the other hand, we also have a speedy trial issue out there, and speedy trial issue will trump an ineffective assistance of counsel challenge every time. So I think that because Judge Boyce has adamantly said, I'm not going to sever this case, he is going to deny the motion to continue. And I think we're going to have a trial in April. And I think the judge is going to make some findings that there is good cause to extend her speedy trial past what her attorneys say is the deadline on February 21st to April 8th because of the scheduling through Ada County. But I don't think that Judge Boyce is going to agree to set this over until the fall because Jim Archibald has already said that he is not going to cotton any more delays because she has not waived her speedy trial right. So now we come to the part where we're going to take some questions. So I would love to hear questions coming up, and we'll see what happens. I did get a question earlier today wanting to know whether I thought Judge Boyce was going to change his mind about live streaming the trial. And I think there's a maybe 50-50 chance. Judge Boyce has not proven himself to be a guy that backs down from a decision or changes his mind. And so I would be, on the other hand, I think that when he made that ruling, he was not taking into consideration the absolute, the crowd. I was trying to think of a better word, but the crowd that is going to attempt to get into the courtroom. He didn't take into consideration the hardship that it will have on he didn't take into consideration the hardship that it will create for the families who would like to participate or view the trial, as well as the families of the victims. So I think I think there's about a 50-50 chance that he will reconsider his decision when it comes to the trial. I don't think we're going to see any change until the trial. I don't think he's going to change his mind about um, live streaming the case. Hi, Tara Wells. Thank you so much. This gives me a great opportunity to remind everyone that all of your super chat donations that come into the channel go directly to our moderators. And I want to thank you so much, because we were able to move a little cash in their direction right around the holidays. And I know that it was deeply appreciated. So Tara Wells asks, have you ever defended someone accused of as serious a crime as Brian Kohberger or the like? So while I was practicing, for most of my practice, I had a young child, and I was in a community where folks, a smaller community where people know one another. And so I chose not to do death penalty work, only because it was much more high visibility. And I didn't want my young child to be exposed to that, or to have folks talking to her about what her mom was doing. I was very cautious about publicity in general. I had an agreement with the courthouse reporter, who was also a mom, about when she would run my name in the paper associated with a case, only because I didn't want to have that rub off on my child. So I didn't do death penalty, but I did everything but death penalty. So I did attempted murder. I did accessory to murder. I did complex felony work. I did sex abuse cases, and I did juvenile complex felonies, including attempted murder. So I had experience doing those, although I didn't ever do death penalty work. Thanks for the question, and thank you so much for the donation for our moderators. Hi, Janet. Janet's question is, given the change for Lori's defense that you just outlined, what might his strategy be? Blame Alex seems too simplistic to me, but I'm not a lawyer. You know, we've talked about this before. The Soddy defense, SODDI, some other dude did it, is often the only defense that a criminal defense attorney can turn to. And in this case, it seems like the likely target to have that blamed on would be Alex Cox, because he's dead and he can't defend himself. I do still think that Lori and Chad are going to do a bit of turning on one another. We know that Chad has telegraphed that his defense is going to include that he was not involved, and that he was a dupe to the scheme between Lori and Alex, and that he was simply overwhelmed by her animal magnetism. So, Claire asks, how do you become a death penalty lawyer? That's a great question. In every state, if you are appointed by the state, now we've talked about this before, John Pryor has never tried a death penalty case. He is, however, retained. And when you retain an attorney, you are responsible to make sure that your attorney has the proper qualifications to represent you. But if the state is paying for your attorney, they demand that the attorneys meet certain levels of qualifications. So every state is a little bit different, but in general, you have to have had experience trying complex felony cases, so serious and violent felony cases, and you have to have at least you have to have served as second chair, as the the assistant attorney on at least one death penalty case. And you also have to be familiar with the ABA guidelines on defending death penalty cases, which is sort of the gold standard for how you put defend a death penalty case. So that that ABA guide is, I think it's about 100 pages long. I haven't looked at it in a while. And it really outlines the responsibilities and the things that a death penalty case should include. So you need to be familiar with those guidelines. And you also, in many states, you also have to participate in continuing legal education, specifically on the issues of death penalty cases and specifically on the process of mitigation. So hopefully that explains it. Mitigation is when you're putting on your case to the jury that they shouldn't impose the death penalty. So Sabrina Holmes says, do you think the comments made by Brian Kay's public defender in Pennsylvania could harm him at trial if competency is raised regarding his calm demeanor, smart, easy to talk to? No. I mean, I think that his public defender in Pennsylvania was free to give his impression of his client, and he was free to say his demeanor was calm and intelligent, and he asked intelligent questions, and that did not give me personally any concern about his level of competency. I think he's free to say that. Whether or not his Idaho team will now want him to be evaluated, mental health evaluation, it's likely, because it really is kind of part of the death penalty good practices, best practices for defending a death penalty case. Generally speaking, when the defense refers their client out for a mental health evaluation, unless they intend to offer that information at trial, they don't necessarily have to share it with the prosecution. So they have the opportunity to have their client evaluated and be reassured that their client isn't harboring some kind of underlying mental health disease or defect, and is competent to go forward and aid and assist in their defense. I think that everybody we've heard from who has had contact with him has said he's smart and, if anything, a little pushy, takes over classes, thinks he knows best, but certainly is competent and is tracking on all cylinders. So I think there'll be an evaluation because that's best practice, but I don't know that his defender in Pennsylvania really did him any harm one way or the other about it. Brown-eyed girl, my favorite moderator, one of my favorite moderators. Question from Grav Falls. Does the gag order on the Moscow case mean the probable cause affidavit won't be released? I don't think so. The gag order has to do with information that will be in the discovery materials. But as far as I know, legally, unless the court is sealing it for some compelling reason, the probable cause affidavit needs to be released. So I think we're going to see it, and I think we're going to have a much better idea of what they put together in order to identify Mr. Kohberger as the probable suspect. The gag order doesn't have anything to do with the probable cause affidavit. If the court decided, as they did in Delphi, that they were going to seal the probable cause affidavit, the court would have to enter a separate specific order to seal that. And then it would likely be temporary and they would release it at some point. Good question, though. Kimberly, do you think they'll seek the death penalty on Brian Kohberger? I would be surprised if they don't. The crime was very brutal, very personal, stabbing 4 young college students to death. It seems to me that it would probably rate the death penalty. That will be entirely up to the prosecutor, and the prosecutor will make that decision after having reviewed all of the evidence. It's not only the nature of the crime that determines whether or not the prosecutor will seek the death penalty, but it also depends on the depth of the evidence, how easy or difficult it will be for the prosecution to prove their case. And it also has to do with whether or not there are any circumstances that could mitigate the death penalty. So that's a great question. That's really an assessment that has to be done by the prosecution. I would be surprised if they don't seek the death penalty, although we've had discussions before on this channel about the fact that the death penalty is kind of waning in popularity. So we're seeing a lot fewer death penalty prosecutions and certainly many fewer executions. And in some states, including Oregon, recently, all of the people who were on death row, their sentences were commuted by the last governor because of the difficulty in carrying out those lethal injections, because of the inability, the inaccessibility of the proper drugs and chemicals that are used in an execution. So, Brown Eyed Girl just posted this and we just talked about it. So yes, I think the probable cause affidavit will be released. I want to thank that we have 368 folks in chat. Thanks. I know that you guys could be spending your time with doing other things. So I appreciate that you are spending it with us tonight. I can take a couple more questions if there's a couple more out there. I do want to once again thank our moderators, Brenda and Michelle. They do a fabulous job for us, and I want to tell you that there's no way I could do this without them, because I can't walk and chew gum at the same time. And if you've seen any of our early attempts at me reading the chat while I'm chatting, you know how much I need them and value them. And so I really appreciate all of your donations that come in that go directly to them. KMW 208 Life. 208's our area code. You must be here. In Idaho, did he hire Idaho defense attorney, or are Idaho taxpayers paying for his defense? He has been appointed a court-appointed defense attorney team. So that means that the state will be paying for it thanks to the taxpayers. Most states have a budget that they set aside for public defense, and so we will see, similar to Lori Vallow's team, which is 2 defense attorneys, at least 1 investigator and 1 mitigation specialist. That's what we'll see soon. How can they reconstruct the crime when they have no idea what actually took place? What happened first or last? I think those are great questions, and I think that is going to be developed as time goes on. There are things that you can tell from the crime scene. Thank you for the question, Linda from Texas. There are things that you can determine from the crime scene, such as perhaps who the sequence of events, but you can tell the direction of cast off blood. You can tell the position of the people who were involved. You can tell a great deal about what happened from the crime scene. That said, they're going to have to combine that with the other information that they have in order to reconstruct the crime scene. It's not really just about going in and taking pictures and doing the crime reconstruction. They will put that together with all of the other information that they have developed over time, and will be able to come up with a timeline and a presumed order of events. It is speculation in some regard, because the only person who actually knows the sequence of events is Mr. Kohberger. And as far as I know, he has invoked his right to counsel and has had no conversations with law enforcement, which I absolutely would expect from somebody with a criminology background. So they will go in and reconstruct based on what they know about the crime scene, as well as the other information that they're able to develop. But that's a good question. Julie, this is a question that I want to end with, because it's been asked of me several times recently. Why would they release the bodies of the young people, the young adults in Moscow, and not the children in the Vallow Daybell case? This is a decision that is made by the prosecution team. And for whatever reason, Rob Wood and his team believe that they may need to revisit the forensic information contained in those bodies. I don't know, because so much of what we know about this case is either sealed or is not available because it's pretrial. Freedom of Information Act requests are exempt. The pretrial discovery is exempt from the Freedom of Information Act in Idaho. It's not in Arizona, which is why we got so much information from Arizona. But anything that is being used as discovery or investigative material in Idaho cannot be released until after the trial is over, because there's an exemption to Idaho's FOIA law. So we don't know why it is that Rob Wood has doggedly refused to release the bodies of the victims in the Vallow Daybell case. Of course, we know Tammy Daybell was buried, and then her body was exhumed, and her body was autopsied. She initially was buried without an autopsy. Later on, the officials got an order to exhume her body and perform an autopsy. We don't know the results of Tammy Daybell's autopsy, because that has never been released. It is pre-trial discovery. And we know that Tylee and JJ's bodies have not been released from the state in order to be in order to have their final burials and their memorials. I know that is a terrible source of pain for particularly for Kay and Larry Woodcock, JJ's grandparents. I know that it has been very difficult for them, and that they would very much like to have the children's remains released so that they can memorialize them. That, as I say, is a decision that is made by the prosecution. Now, in the case of the University of Idaho murders, they didn't have a suspect in custody at the time that the prosecutor agreed to release the bodies. Because we don't know what sort of evidence is potentially might be available to in the Fremont County prosecution might be available in the Vallow Daybell case. We don't have any way of knowing why Rob Wood has been so adamant about not releasing the bodies. But we do know in the Moscow case that the coroner performed autopsies on all 4 bodies. There were not the coroner, the medical examiner. The coroner is not a doctor in Idaho. The medical examiner performed autopsies. There are detailed reports, and I'm certain that they've retained tissue samples, retained as much information as possible, and of course, photographed and memorialized every aspect of the autopsies. So it is more typical for prosecutors to release a victim's remains than it is for them to keep them. It is more common for the prosecutor to be satisfied with the autopsy results and be willing to release the bodies. So I don't have an answer for why the prosecutor has in the Vallow Daybell case has been adamant about not releasing them. I just caught something in the chat that said the bodies were the Moscow, Idaho students, their bodies weren't burned or buried. And that's accurate. So it may have something to do with the fact that the condition of the bodies is different. So I want to thank everybody for joining me. Thank you for your patience tonight with my little slow brain. Thanks so much for all of you being here. I know that you have many other things that you can do with your time. So thank you so much for the 379 of you who are here. If you're not subscribed, please do subscribe. Right now, our programming is very predictable. We go live on Wednesday and Fridays at 6 o'clock Pacific. But once the trial comes up, particularly if the court continues the no cameras order, you're going to want to get notifications because we're going to be dropping content every time something new occurs during the trial. I plan to attend the trial, and we are going to be going live every opportunity we have on YouTube Shorts to give you updates of what's happening in the courtroom. So please do subscribe and hit that notification bell so that you'll be notified when we do go live as we get closer to trial. Thanks so much for everyone tonight for joining us. Thank you for the support for our moderators. I appreciate it so much, and I know they do. Look forward to seeing you on Friday, where we'll be talking more about Vallow Daybell. Friday is our night to talk about all things Vallow Daybell, and I know that we are going to have a lot of things to talk about. One other thing I wanted to point out, I got this really cool camera as a Christmas gift, and it allows me to look at you and to make it seem as if we're making eye contact. So I'd love to hear your feedback on whether or not you enjoyed that and whether or not it makes the podcast experience even better. So I want to thank you all for being here. We'll see you on Friday, 6 o'clock. Be there or be square.